May it please the court, good morning. My name is Michael Wasik. I'm here on behalf of the appellee, Louis Bartram. My co-counsel is here. He's Hunter Malin. He's with the plantation of Ponte Vedra. We'd like to divide our time, Your Honor. I'd like to reserve a minimum of 5 minutes for his presentation. Hopefully I won't take up the full 15. If it pleases the court, I would like to just address some of the points that were raised on the bank's initial presentation. One of the most important things to note, I think, is that in the bank's initial brief, the bank argued, and this is at page 11 of the initial brief, that Singleton was binding authority on this court, that Singleton controlled the outcome of this case. And then after we filed our brief pointing out the differences between Singleton and why we don't believe it was binding authority, in their reply brief they receded dramatically from that position, and they argued that there is no persuasive authority, or there's no binding authority rather, that instead that this court is called to decide upon two competing lines of persuasive authority. So I wanted to point that out, is that in response to our arguments about Singleton, even the bank receded from its prior position. I think today we saw some more of that at the oral argument presentation by the bank, that the argument that Singleton doesn't actually control the outcome of this case.
What's the purpose of an acceleration clause, and who's it designed to benefit?
Well, the acceleration clause, Your Honor, is a contractual, is part of the contractual remedy between the borrower and the lender. It allows the lender rather, to elect to file suit to enforce the entire amount due. It collapses the future payments into a present time, so it renders the future due payments due now.
Is it conditioned on establishment that there's been a default?
Well, in order to...
The bank can't write you, mortgage holder letter and say, look, economy's kind of bad here, we need some money, we're accelerating the mortgage, right? I mean, they can only do it if there's a default.
Well, that depends on the individual contract, but in most mortgage contracts and most loan contracts, that's correct. It's a default of some kind, either a default of payment or a default under paragraph 18 for the due on sale clause, and there's a couple other provisions that sometimes allow for acceleration.
So if the bank says there's a default, but there's not,
yes, then
is the acceleration notice effective?
And Singleton addresses that exact point. If the borrower successfully defends on the basis of a lack of default, because the acceleration depends on the existence of a default, then as a matter of logical consequence, that acceleration must fail. But Singleton...
When do you have a default? Is it when a court says there's been a default?
The mortgage contract defines that a default is a payment that's untimely, and there are other ways to default on a mortgage contract.
As far as drawing a line of when the notice of acceleration becomes effective, do you need a court to say, yes, I find a default?
I don't think you need a positive adjudication to do that. I think the acceleration is effective because what it does, in fact, the Central Home case...
Well, there's no obligation on the borrower to pay the accelerated balance until there's a judicial determination of the default, right?
Actually, Your Honor, I don't agree with that because the accelerated balance, there is a reinstatement option, but unless the borrower affirmatively takes advantage of the reinstatement option that's in the typical mortgage contract, until and unless there's a reinstatement, there is an obligation to pay even without a judicial declaration that it's due.
Okay, but if you get a mortgage foreclosure complaint, you can either say, I stipulate to a judgment, or you can say, I'm defending against it.
Yes.
Prove your case.
Yes.
And proving your case includes proving a default.
Yes.
Okay, and if the default is never proven to the extent that there's a judgment entered saying there's a default, when did the acceleration clause become effective?
The acceleration clause becomes effective under the Central Home case that we briefed the moment that the lender makes some kind of affirmative communication to the borrower that acceleration has occurred. And in fact, Your Honor,
didn't your client essentially admit that he had not paid the mortgage payments and had defaulted? I mean, that wasn't even an issue, a contested issue, was it?
I believe that's correct, Your Honor.
Now, if we accept your argument in a scenario where, there's a failure to make a payment, there's a notice of acceleration, there's a foreclosure action filed, and for whatever reason the case lingers for 5.5 years, and then the borrower, pays all the payments, brings it current, doesn't pay the balance, but brings it current, and the bank then, maybe not recognizing the potential problem, then says, okay, we're current, and they dismiss the lawsuit. Accepting your argument, would that mean that the borrower would no longer have to pay any monies?
Not at all, Your Honor, because what that would be, Your Honor, is a reinstatement. Under the mortgage contract, payment of all the arrearages.
There's no agreement. There's just, they send a check, and then there's a notice of dismissal.
There's no agreement necessary. The reinstatement right is defined in the mortgage contract. And the mortgage contract says you borrower, that's the borrower's right. You, the borrower, have the right to reinstate if you accomplish the following conditions, one of which is payment of all the amounts due and owing. So if the borrower pays all the arrearages and meets all the other contractual requirements for reinstatement, the borrower has that right to reinstate, and that has the effect. That is the only way that I'm aware of that undoes the acceleration.
100% of it. They owe $20,000 in back payments, they pay $15,000. Bank says, well, we're not going to deal with this anymore. They accept the $15,000, dismiss the case.
I would characterize that as a settlement. If the bank then continues to accept the regular monthly payments going forward, the parties can agree to accept a lesser payment in amount of the arrearages. They can compromise the arrearages.
But under your argument, you had a default, you had a notice of acceleration, you would not have had a revocation of acceleration. Why wouldn't the statute apply? The statute of limitations apply.
Because where the bank because the contract allows the borrower to reinstate, and the amount of the arrearages is a subject to compromise between the bank and the borrower. If they compromise on the amount of the arrearages, pay 90% of the amount due, then that would be a reinstatement, and that does undo the acceleration. That would reset the statute.
How about if they pay 50%?
If the bank and the borrower agree that reinstates the mortgage,
How about if they pay zero?
if the bank waives the arrearages, that's a compromise of the arrearages. I think that as long as the borrower complies with, because the bank can certainly waive certain rights under reinstatement.
So if the bank, in this case, then what you're saying is if the bank had voluntarily dismissed, at the case management conference, then you're saying the statute of limitations did not kick in?
I don't think a voluntary dismissal is the equivalent of a waiver of reinstatement without some clear communication to that effect.
0%, we went through 100, if the borrower paid 100% of the back payment, you said statute of limitations would not kick in. I asked you 90%, you said they wouldn't kick in. I asked you 50%, you said it wouldn't kick in. I asked you 0%, you wouldn't kick in. And the statute of limitations wouldn't kick in. So they voluntarily dismissed at the case management conference rather than having the trial judge dismiss it because of failure to appear. Are you saying that the statute of limitations would not have kicked in and they could then sue for any subsequent defaults?
The pendency of the court action and whether a reinstatement has occurred are two separate issues. One is a procedural issue for the court. The other is a matter of contractual arrangement between the parties. The parties can contractually agree to waive certain conditions.
I never said there was an agreement.
Okay. If there's no agreement, then there's no reinstatement.
Okay. So then if the person paid 100%, but there had been or 90%, but there had been no agreement, and the bank dismissed the case, accepting your argument would mean that the borrower would never have to pay another penny on the mortgage.
I think that's correct, because if there's no reinstatement, then that doesn't take place. One other issue I wanted to respond to very quickly that counsel raised on his presentation. He talked about the policy implications of what would happen if this court affirms the decision below. And I think, by the way, counsel correctly stated that this is something that kind of calls out for an opinion, because trial courts seem to be looking for some guidance on this. So either way the court rules, it would probably behoove the court to offer that guidance to the trial courts. But one of the things he raised is the issue that it would provide incentives for the banks to move.
You don't want a PCA?
I'll take it if you're going to give me one. I'll take it. But I think as a matter of policy, this case has implications far beyond this case.
This is bothering me about this particular case, and this is language right out of Singleton. It says, well, it is, and I understand Singleton had to do with res judicata, and that was issued, but the language says that while it is true that a foreclosure action and acceleration of the balance due based upon the same default may bar subsequent action on that default, and acceleration and foreclosure predicated upon subsequent and different defaults presents a separate and distinct issue. And so it seems to indicate that it doesn't really matter. I mean, if there are subsequent defaults and it doesn't make payment, those are separate issues, and each one of those can be a basis upon which to bring an action, despite the fact that there had been an acceleration and a default before.
Well, a couple of points.
Before, and a dismissal.
I agree. A couple of points about that. Actually, that's the language I have highlighted in my copy of Singleton as well. It says, while it is true that a foreclosure action and an acceleration of the balance due may bar a subsequent action on that default, what that tells us, by the way, is that a borrower may win a foreclosure case, and still there may be a valid acceleration and default, because if a borrower wins for reasons other than disproving the default or disproving the acceleration. For example, it has been my experience that banks will frequently, for procedural reasons or logistics reasons, voluntarily dismiss cases on the day of trial if their witness doesn't show up or if they don't think they have the evidence to go forward. But the court never reaches an adjudication on the merits of the case, and so there may be reasons to dismiss the case in that way. But there may be, in such a circumstance, a valid acceleration and a valid foreclosure action, even if it's been dismissed.
It says that it doesn't prohibit actions on subsequent defaults.
Right.
And so it seems to me that what the court's saying is, even though there was a dismissal in this case and there was an acceleration, it doesn't really matter. If there are subsequent defaults, you can continue to bring the action.
I think
if that's the case, it's hard to come to the conclusion that concerning the issue of statute of limitations, why the statute of limitations would not have run if, the acceleration and the prior action really didn't matter, as long as there were subsequent defaults and the payments aren't continuing to be made.
Well, I think the issue, it's important to go back to a question that Judge Orfinger asked earlier, which is what is the distinction between equity and law? And Singleton is dealing with questions of equity, and it expressly, the second part of the opinion expressly says, we're reaching this decision because we think it would be inequitable.
It seemed to me to be then the court goes on and talks about the equitable issues, but what the court is saying here is that the fact that there was a dismissal and the fact that there was a foreclosure action that was dismissed and the fact there was an acceleration doesn't really matter. If there are subsequent defaults, that triggers another cause of action.
I understand that, and again, that's all in the context of res judicata rather than the legislative mandate.
But how do you say that it applies res judicata and you can file different causes of action, but it doesn't apply to the statute of limitations?
Two reasons, Your Honor.
It bars the subsequent causes of action.
First is, and we make this distinction in our brief, is that the issue of res judicata is a matter deciding whether a matter has already been decided. Statute of limitations accrues when the matter begins, so it's a different point in litigation, and so I think it's a different analysis.
And they both, is res judicata a legal defense or an equitable defense?
Well, res judicata is an equitable issue, and that's why this court felt free, the Singleton court felt free to modify that, as opposed to the legislative mandate, which is, if it's otherwise constitutional, this court, I think, is bound by.
Let me just ask you about that, because I'm looking at some other language in Singleton. And it says, we must also remember that foreclosure is an equitable remedy, and there may be some tension between the court's authority to adjudicate the equities and the legal doctrine of res judicata. The ends of justice require that the doctrine of res judicata not be applied so strictly so as to prevent mortgagees from being able to challenge multiple defaults. So, they seem to suggest there that, like a statute of limitations, res judicata is a legal concept which seems to be somewhat in tension with the equitable remedies of foreclosure, and they defaulted to the equities and basically said, so what on the res judicata? And I have some sympathy for your position here, but I'm wondering why that same analysis doesn't apply here with the statute of limitations, because I agree with you, it simply takes a snapshot of what happens at a different point in the proceeding.
Well, and the issue here is, again, is that res judicata is a judicially created doctrine, and I want to address Judge Solaya's question as well, because I don't think I've completely addressed that, and I want to return to that. It is a judicially created doctrine that the courts have imposed for sake of judicial economy. We don't want to be relitigating issues. Now, and that's what will happen, frankly, if in cases where statute of limitations doesn't even apply, is we will actually multiply foreclosures in a case where the courts are already strained. But as to the question of whether or not there can be a future default where the amounts have been accelerated and there has been no deceleration. Remember, Singleton says that in certain circumstances, and this is the crux of the case, Singleton says that in some instances, the acceleration, the borrower disproves the default, disproves the acceleration. The logical consequence of that is that that telescoped payment then is exploded back to where it was, and that those future payments then resume the normal due dates. But if the acceleration is valid, those future payments are already due. There is no future default. So only if and this, by the way, is the point that the bank originally made in its the main point it made in its original brief, is that somehow the acceleration is undone. Unless you have a valid method of revoking the acceleration, then there are no future payments due once it's done. Singleton says that in certain circumstances, that acceleration can be undone if the borrower proves a lack of default, if the borrower proves a lack of acceleration.
Let me ask you this. Singleton, references this defense as res judicata as a legal defense, like the statute of limitations. Assuming that's the case, your brief, correctly observes there's a different policy consideration behind the statute of limitations and behind res judicata. Why should, what's your argument as to why those policy differences should result in a different result in this case from Singleton?
Well, I don't think it does result in a different case from Singleton, because as I was just saying, the Singleton simply stands as the proposition under certain circumstances where the borrower affirmatively disproves or where there's an adjudication that no acceleration took place, then those future payments are still due knowing the acceleration is undone. But where there is no such positive adjudication, then in those cases, those future payments are still due. So you can apply Singleton and still, in its narrow, self-defined narrow scope, as we briefed, and still find for the Bartrams in this case. At this point, I've only got 2 3/4 minutes left. I'd like to reserve my colleague. Thank you.
May it please the Court, Hunter Mount on behalf of the plantation. I'd like to quickly answer Judge Wyatt's question, which I think will then answer Judge Evander's question. Your Honor, the portion you read from Singleton, as co-counsel pointed out, uses the word may. In that same paragraph, the Supreme Court in Singleton explains when it applies. And it applies, for example, a mortgagor may prevail in foreclosure action by demonstrating that she was not in default on the payments alleged to be in default, or that the mortgagee had waived reliance on the defaults. In those instances, the mortgagor and mortgagee are simply placed back in the same contractual relationship with the same continuing obligations. Hence, an adjudication denying acceleration foreclosure under those circumstances should not bar subsequent action a year later. And 2 times in the Singleton case, they say that it does not necessarily, that res judicata does not necessarily apply. So it applies sometimes, it doesn't apply other times. And it tells you when it doesn't apply. And that's where the default alleged by the lender is not actually a default. So if you don't have a default, you cannot accelerate, and therefore there's no effective acceleration. So if sometime later there is an actual default, then the lender can actually accelerate or bring an action, and there wouldn't be res judicata. So, and I would argue, I would submit, Judge Evander, that the policy reasons for Singleton, even though they're 2 different principles, apply somewhat equally to statute of limitations. The reason is because Singleton is limited to a situation where a borrower can prove that the default did not occur as alleged by the lender, or there was a waiver, which goes back to Your Honor's earlier question about what if payment submitted for this amount, percentage, or whatever. There would be an argument of waiver in that case. If a borrower submits payment, lender accepts it, then that creates the potential argument of a waiver. And waiver is dealt with in Singleton. And when you have a waiver, res judicata shouldn't apply.
What if in this case, the day before the case management conference, there was a voluntary notice of dismissal by the plaintiff? Can he?
Yes.
I mean, can he sue again?
Your Honor, in Florida law...
The judge's order dismissing for failure to appear at the
That's right.
case management conference, there's a voluntary dismissal. Has the bank waived its right not only to pursue the suit for the past payments, but for all future payments?
If the 5 years had run from the date of acceleration. Your Honor, the issue of whether that would constitute an affirmative action revoking a prior acceleration has not been decided in Florida. I would submit, I cited in my brief 2 New York cases, 1 Texas case, which do say that when the lender takes an affirmative action, such as dismissing a case, that the acceleration would be revoked. But in those cases, the court dismissed the action, one for failure to attend a certification conference, which is similar to a case management conference, and the other on procedural grounds, I think for lack of prosecution. And in those cases, the court found that that was not in any way an affirmative action by the lender. The lender did nothing to revoke the acceleration, just as in this case. In this case, in 2011, the case was dismissed because the lender did not show up at a case management conference. The lender never moved for rehearing. The lender never moved to reset the case management conference because there might have been a conflict. The lender never appealed. The lender didn't file a second foreclosure action before the 5 years had run because there was still some time left. The lender waited until Lewis Bartram filed a cross-claim in a subsequent action to cancel the debt before so the dates are May 5th, 2011, first foreclosure action dismissed. April 25th, 2012, Mr. Bartram files a cross-claim against the bank in Patricia Bartram's case, then asks the court to take judicial notice of the 2006 case, moves for summary judgment on June 6, 2012, and the hearing's held on July 10, 2012. Well, the bank finally files something in any of these cases after July 10, 2012, after the hearing on the summary judgment motion. The bank took no action, affirmative action whatsoever, to revoke or attempt to revoke the acceleration. I would submit, Your Honor, also an effective acceleration can be accomplished under the Central Home case by merely sending a letter to the borrower. You're in default. Well, first you've got to send that 30-day pre-acceleration notice, but then you didn't cure 30 days later. Now we've accelerated the debt due. Here's the notice. What if the bank doesn't file foreclosure action for 5 years? That's an effective acceleration. And the statute of limitations runs because the bank elected its remedy. The bank has an option to elect to accelerate. The bank in this case, in May of 2006, elected to accelerate the debt, and the bank took no affirmative action to revoke that acceleration. One other point I want to mention from the U.S. Bank's argument, Mr. Swank argued that the issue of the borrower controverted foreclosure.
Okay, you need to wrap it up because you're well over your time, so go ahead and wrap it up if you can. You're about 4 minutes over your time.
Yes, Your Honor. May I have one more minute?
Go ahead.
Thank you.
And I'll give you some extra time, opposing counsel, I'll give you some extra. Go ahead.
Okay. I just want to point out that in the 2006 case, each time the bank moved for summary judgment, Lewis Bartram never opposed the summary judgment. Lewis Bartram didn't file an affidavit saying I wasn't in default or the acceleration wasn't effective. And in this case, Your Honor, when Lewis Bartram moved for summary judgment, the bank did not file any opposition saying, oh, by the way, we now realize the default that we alleged in the 2006 case wasn't valid for these reasons, or the acceleration that we elected to go forward with in the 2006 case wasn't effective. Those are things, if they were true, that the bank could have raised in defense of the summary judgment. They did not because they're not true. They were not facts of the case. But if they were true, then perhaps they come under Singleton because maybe you don't have a valid default or maybe there's a waiver. But in this case, everyone agrees there was a valid default in January of 2006, and in May 2006, when the first foreclosure action was filed, the bank elected to accelerate. They were entitled to accelerate under the contract, and they never revoked that acceleration. They never took affirmative act to revoke the acceleration.
Okay, you need to wrap it up. Okay.
For those reasons, Your Honor, we'd ask that the lower opinion be affirmed.
Okay, thank you.